Ladies and gentlemen, please stand by. We are about to begin. Good day, everyone, and welcome to the Mandatory Disclosures, Best Practices for Protecting Your Company's Interests and the Current Compliance Environment conference call. Today's call is being recorded. And now, your host for today's call, Mr. Paul DeVolt. Mr. DeVolt, please go ahead, sir.
Thank you. Good afternoon, everyone. My name is Paul DeVolt, and I am the chair of the Government Contracts Group at Venable. I appreciate you taking time out of your day to join us today. On our panel today, we have what we hope is an excellent presentation that everybody's going to get a lot out of. On the panel today is Diz Lacaria of Venable, Melanie Topman of Venable, Jesse Waters of Cetera, and Jeff Clayton of Baker Tilly. And I'll just go ahead and ask all the panelists to introduce themselves. Jesse, why don't you start?
As Paul said, I'm with Cetera. I'm the general counsel with Cetera, and we're mid-size national security contractor, and happy to be here.
Jeff.
Thanks, Paul. My name's Jeff Clayton. I'm a partner in Baker Tilly's Government Contracts Advisory Services practice. We're an accounting and consulting firm. We have a practice where we do just what it sounds, assist government contractors and their counsel in a lot of cases on all types of matters related to pricing, proposals, cost accounting, compliance, and in some cases mandatory disclosures as well.
Melanie?
Hi, I'm Melanie Topman. I'm a counsel here at Venable. I specialize in government contracts compliance issues, which I break down into a couple different buckets. That includes mandatory disclosures, the subject that we're going to discuss, the FCA and fraud investigations, as well as general nuts and bolts compliance. How do we comply with our 200 to 300 page contract of gibberish?
And Diz?
Yes, Diz Lacaria. I'm a partner in the Government Contracts Group here at Venable, as Paul mentioned, and similar to Melanie, I specialize in government contractor compliance. Ranges from helping contractors understand their contract requirements from the get-go, and then helping them unwind potential issues as things unfold during the course of their performance. And sometimes that includes making mandatory disclosures and walking them through that process.
All right, so we'll go ahead and get started. The objectives of today's presentation are really threefold. We want to make sure that when we're done that everybody has a working knowledge of the fundamental principles of the FAR mandatory disclosure rule. We want to ensure that people have the folks on the phone have an understanding of what the government's expectations are for contractor cooperation. And then hopefully we'll have time at the end to talk about some of the key takeaways in this area and to put your company in the best position that you can avoid fines, penalties, or God forbid, suspension and debarment. So with that, Melanie, why don't we go ahead and talk about what is the mandatory disclosure rule? I mean, just generally, how would you describe it?
Confusing. No, generally speaking, the mandatory disclosure rule it's a provision among the FAR clauses that's included in really all of your contracts, likely, fully. It requires contractors to disclose significant overpayments or credible evidence of a violation of certain civil laws, which includes the Civil False Claims Act, which we'll talk about today. Generally, if I were to, take out the legal garble, I would say the mandatory disclosure rule says if you've messed up significantly and it has financial consequence, we want to know about it. And I think that's a little bit different for companies that are not used to being in the government contract space because they're thinking, well, we have to self-report all of this. Yeah, I mean, your requirement is to self-report, and we're going to walk through a sort of framework of understanding when you would need to do that and how you would go about doing that effectively.
And what contracts does this apply to? Does it apply to every contract or just certain contracts?
So the provision provides that it should be included in contracts of $5.5 million or more, and then that run for a duration of more than 120 days. But that's somewhat misleading because a lot of organizations, they do their business with the government through what's called the GSA schedules, Federal Supply Schedule, or through various GWACs. And the GSA schedules, for instance, take the position, even though a scheduled contract doesn't obligate a single dollar, they take the position that it's anticipated that you will get more than $5.5 million, and it will run longer than 120 days. And so they do include that provision in their contract. Therefore, it applies to all the task orders issued under a schedule. So while the thresholds seem high to some, it has a lot more applicability than you would think, given some of the positions agencies have taken with respect to hitting that threshold.
So, Melanie, is this a mandatory flow-down clause? Do prime contractors need to flow this down to their subcontractors?
You're required to flow it down, again, like Diz described, for $5.5 million and a subcontract that has a period of performance for more than 120 days. One large caveat to that, though, again, is if you think that the aggregate value of your subcontractors may be more, you may take the position that we want to flow this down so that we have better insight into what's going on with our subcontractors. And as always, I think with subcontractors, you want to have enough reporting requirements, regardless of this clause, to ensure that you have the appropriate information from your subs.
I want to talk about, if something comes up within a company and a company makes a decision not to disclose, what's some of the risks that arise if a company opts not to disclose something that's covered by this provision?
The risk can vary. I mean, obviously, if your customer finds out about it and they found out that they overpaid or that they were mischarged, they'll be very upset or potentially upset, and they could, refer that to someone to take a deeper look, or they could put that in your past performance. But the real big stick here is that the provision actually creates a new basis for suspension or debarment. What that means is that suspension and debarment officials within the federal government have certain bases, certain indicators that this is something that I can debar someone for. And this is a specific basis. If a company or its principals have credible evidence of an issue and they decide not to disclose, and it comes to light later, the suspension debarment official can actually take action not based on what the conduct is, but solely based on the fact that you didn't disclose. Now, the conduct itself may have, serve as a basis as well. So you would have multiple bases potentially for debarment, which, makes that even more challenging to get out from under. So that, candidly, is the biggest stick. But there are, a number of practical issues that if it ever came to light that you didn't disclose, your customer relationship might be harmed as well.
And Jesse, how does the company evaluate the risk of not disclosing? Is it a serious risk, a slight risk? What's the business analysis that goes on?
Well, as the general counsel, it's a serious risk. If it's a business person, there's no risk. Obviously, the most, as this mentioned, there are customer implications, but that's not really my biggest concern. Is we're 100% in the government space, and the last thing we need is a suspension of debarment or even a proceeding, frankly, because that's going to impact our business significantly. You're done. You're out of business if you obviously suspension of debarment. It's not like a small piece of what we do. So this is a serious risk. So we take it obviously very seriously when we're looking at the issues, as I think anybody in the government space has to.
And Jeff, one of the things that's also covered by the mandatory disclosure rule is significant overpayment. How do companies assess whether something is a significant overpayment or not? Is it some percentage of the overall contract? Is it anything over $100,000? So how do you assess that?
It's a good question. It certainly is a term of art rather than science, right?
Yeah, it's my favorite question. Yeah.
You're talking a bit about risk a minute ago. I think it can be specific to each and every company and their counsel and what their kind of risk tolerance is, right? I've often seen companies look at it, as you suggested, as a percentage of the total contract value. I think when you get to the 10 or at least $100,000 plus range, you can probably throw that out the window because it's probably significant even at $1 million contract at that point.
Yeah.
I can also say in working with various IGs that what they view as significant is probably always going to be lower than what you or I view as significant. So you kind of have to keep that in mind as well.
Mm-hmm. It's interesting. The other thing that's interesting, too, is that we've had clients that have come in and said, look, we have a potential false claim that's only $2,500. Do we need to disclose it? And because it's so small, in the conversations I've had with the mandatory disclosure officials, they've been loud and clear that there's no de minimis rule for fraud. That it's
Yeah,
fraud.
absolutely. I mean, and maybe we'll get to those later, but I've had to disclose things that, that they already knew about, frankly, because sometimes they do investigations, on the customer site, they do, badging checks. And it's a very small dollar amount, and they already know about it, but we disclose anyway. It's just not worth the risk. It's a false claim technically, right? So,
I think if it's an overpayment, and you can classify it as that as opposed to fraud, you need to make a payment back. You need to work with the CEO. It's a question of whether you need to involve the IG, right?
Yeah, and I think, it just says disclose to the government for significant overpayment. And so I think, the goal is to try to keep it business person to business person and keep the IG out, I think would be sort of the takeaway from that.
Yes.
I mean, one of the other things that's kind of troubling about the rule is, you have to make this disclosure if you identify credible evidence. How do you know when's evidence become credible? Is it 75% likely? Is it 50%? Is it 30%? Like, how do you figure out what's credible evidence?
So
that's complicated.
it is complicated. Let me say, so credible evidence, just as a legal standard, so everybody gets their head around this, is actually it's a lower threshold to meet than the preponderance of the evidence standard. So under the Civil False Claims Act, it's a civil standard. If you are more likely than not to have acted recklessly, then you can be in violation of the Civil False Claims Act. Credible evidence is backed up a step further from that. So, if you have, the way I've sort of described it to clients in the past, and, it is very fact specific, but if you have an allegation or concern, and then you have verified that concern is real in some other manner, I do think that you have crossed the line from the IG's perspective into credible evidence. You have corroborating evidence at that time that you have, certainly violated the Civil False Claims Act.
The next thing I want to talk about is how much time do you have to disclose? I mean, do you have unlimited time to disclose, Melanie? Do you have to do it within 2 weeks? I mean, how long do you have to make the disclosure after you identify a problem?
So this was an issue that was actually raised directly when the rule first came out, and it's tied directly to the credible evidence standard. So you have to disclose in a timely manner when you have credible evidence. What the FAR Council said was, if you do not have credible evidence, if you are still deciding whether there's credible evidence, then there's no disclosure requirement. At the point in time that you get to credible evidence, then you need to go ahead and make your disclosure. So it's very much tied into this idea that you have the opportunity. If you get a whistleblower issue come up, or something comes to your attention through an audit, you have the opportunity to investigate that issue, to look at the issue and say, is this credible, or has somebody misunderstood the facts? But at the point in time that you do determine there's credible evidence, you should make the disclosure shortly thereafter.
And Jeff, based on your experience, how long does it take to get your arms around an investigation? I know you work a lot in the cost arena. How difficult is it to get to, the nub of the issue and figure out whether you have credible evidence or not?
And really the basis for the issue, the size of the company, their systems, your access to people there, their records, can all play a role in that. I think we might talk a little bit about this, later. There are kind of two steps here, right? Which is credible evidence, and then what's it all mean? What's it all equal to, right? The credible evidence piece, it can be a matter of. That can be something that's determined fairly quickly. It can be a matter of weeks, months. The investigation piece, that can be measured in months, often, sometimes in years, depending on the situation, right?
Well, Jesse, given how long it can take to get your arms around the facts in some cases, does it ever make sense to make a two-part disclosure to the government?
Yeah, absolutely. Just like, Jeff was saying, you might find out right away that you've got an issue to disclose, but you don't have all the facts yet. So, I mean, it may take, and I've seen this, not at Soterra because we're perfect, but in other situations where, yeah, you'll know that there's an issue that needs to be disclosed. You just can't get your arms around it. It takes a long time because, there's one person, in the law department. There's, maybe the records aren't great and the people are spread around that you need to talk to. So, yeah, you make the initial disclosure. You say, yeah, this guy Paul, I don't know, he did something bad. And then later on you follow up with the rest of the facts when you get the rest of the facts. So I think, there are definitely plenty of situations where you would want to do that.
What do you see as the benefits of a two-part disclosure?
I think the benefits are significant, and Jeff and Jesse kind of alluded to this already, which is it can take a lot of time to determine the extent of an issue, but it doesn't necessarily take as much time to determine that there is in fact credible evidence. And the time between those 2 points, between weeks and between months, is time that if you're not disclosing, then the government, if it learns of it and figures out that you didn't disclose, then you're at risk. It also is a time period where a whistleblower could file what's called a qui tam action under the False Claims Act, which is a private right of action under the False Claims Act, and be the first to do that. So the benefit of a two-part disclosure is when you get that disclosure in, even if it's only kind of a partial disclosure, it puts a stake in the ground that at this point in time, you made the government aware that this is an issue, that there is even you could even say potentially credible evidence. You can kind of be a little careful with your wording so as not to admit anything, but you put a stake in the ground that it says at this point we are examining these issues because there may be an overcharge or indicia of a FCA violation or something. So that then cuts off subsequent findings by the government that they could then go to an SDO to say, hey, you never told us, or the filing of a qui tam action where they would be the first to report this issue. So it does have a lot of benefit to getting that first disclosure in, but there's cost benefit because if it turns out to be nothing, you're still going to have to follow it up and deal with it. So you do want to make sure that there is in fact credible evidence, and be careful with your wording. So if it turns out to be nothing major, you can kind of back things off a little bit on the secondary, more fulsome disclosure.
Yeah, no, I think that's a good approach, and I think a lot is driven by sort of the complexity of the organization, the records, how far people are spread out. I mean, sometimes, what we've seen is that when people are asked to leave a company, I mean, one of the first things they tend to do is to go get an employment lawyer who writes a letter demanding severance, medical pay, or whatever, and then the last paragraph or next to the last paragraph invariably says, oh, by the way, my client was aware of some potential irregularities in the bookkeeping on this contract, and now they've created a huge mess.
Yeah.
So it's kind of just
Everybody who gets fired in a certain environment when funding is low has all of a sudden miraculously been harassed and seen fraud.
Yeah.
I mean, it's a little bit of a trend.
GC, yes, that's absolutely accurate. Everybody makes all sorts of claims, so.
And some of them maybe, you have to treat them as if they're true.
Yep, you have to. Absolutely.
Just to determine if they're true, but there's an increased incentive to blow the whistle when you're on the way out.
Does one of you, Melanie, talked a little bit about what companies have to do when they're making a disclosure. So why don't you just describe just generally sort of what has to be done?
So it's not really prescriptive, or at least it's not prescriptive in the clause or in the regulation, really, in terms of what you have to do. Now, there are government forms. As kind of a practical tip, I would always advise you not to use the government form because the government form does require certain kind of essentially admissions. And so it's not that prescriptive, but the practitioner's tip I think that I would provide is that you want to provide as much detail as you're certain about. Because what you want to do is you want to demonstrate to the government that, look, we recognize there's an issue, we take it serious, and we are doing everything we can to unwind it and also ensure that it doesn't happen again. And that gives the IG and the customer and ultimately a suspension debarment official, if it ends up on his or her desk, the comfort that the organization is acting with a certain degree of integrity and business ethics. I think all agencies and every government official I've talked to, they recognize that people are going to make mistakes, that no one's perfect. Contractors are going to make mistakes, but it's how you deal with it. And being transparent and open and cooperative about it is critical. Now, that doesn't necessarily mean waiving attorney-client privilege, but it does mean providing them with enough information that they understand the issues and they understand the impact, the number, essentially. And that may come in the course of 1, 2, or even 3 disclosures, because it may take time. But it's really a matter of just being, I think, fulsome with the story and demonstrating to them that you've got your arms around it, and they don't need to come in and do a full-blown audit because they trust the work you've done.
One of the things I want to highlight about what Diz is saying is that it is not required of contractors to admit to liability. It's not required of contractors to waive attorney-client privilege. So how do you accomplish that and still make a disclosure? What you do is you keep in mind that the standard for disclosure is lower than the standard of liability. So if somebody were going to take you to court, they would have to prove more. They'd have to prove more intent. They'd have to prove more knowledge, and we'll talk about that in just a little bit. So the key to disclosures, I think, that we've found is that you can be very specific with the facts without drawing legal conclusions about those facts. You do not need to say, we have violated the Civil False Claims Act. In fact, I don't think anybody on this call, unless you're a judge, is capable of making that determination. You don't have the authority. What you do have the responsibility to do is to say, is there credible evidence that the Department of Justice would take issue with this because of the Civil False Claims Act? We think there is, and for that reason we're making this disclosure, but you do not have to admit to liability at all.
Yeah, I mean, we've had letters that have gone in that we say we filed out an abundance of caution and try to temper the language. I think the other thing that I'm seeing now is that when you make your disclosure, you got to think about which agency holds the contract, like within DOD, if it's a Navy contract or an Air Force contract, because what we've seen is that it goes into the DOD IG and it makes its way over to the suspension and debarment official for a specific department, and they're looking at that disclosure letter and asking, how did this happen? So there have been a couple times, knowing who the customer was, that we've had to write a more detailed letter than we otherwise would write, explaining sort of what our procedures and processes are that tried to prevent this, but the person just happened to be a rogue. So, as you're developing your strategy, you really want to factor in, what agency you have the contract with and how their suspension and debarment official may take a look at it. So, it's an interesting area. I think that I want to talk briefly about some of the other obligations that the mandatory disclosure provision puts on a company. And Melanie, why don't you talk about those?
Sure. Just to sort of frame this up, the mandatory disclosure rule is part of a larger sort of code of conduct and ethics requirement under FAR 52.203-13. The point of this provision is really to get contractors some guideposts for how they need to be working with the government and how they need to be structuring their compliance programs. So your requirements are, one, you're required to have a written code of conduct, basically a statement from the agency that says, from the contractor that says, we will act with integrity and here's how we intend to act with integrity. You're required to make available to each employee this code in the performance, each employee that's engaged in the performance of the contract. Most people view this as an electronic accessibility issue, so you may put your code on your website. I recommend that you have each individual sign review the code of conduct, train on the code of conduct at orientation, and sign it. Say, yes, I understand my obligations under the code. You may want to do that annually. You're required to exercise due diligence to prevent and detect criminal conduct. This is this idea that you are, compliance is not just responding to the things that come to you that are bad, but that you are out there as a company doing the good work to detect and prevent fraud, waste, and abuse. And you're also required to otherwise promote an organizational culture that encourages ethical conduct and a commitment to compliance with the law. So this is what the suspension and debarment officials always talk about. They want to see the living, breathing, everybody's laughing around me, the living and breathing ethics. And it is cheesy, but it is true. They want to understand sort of what your culture is in your organization. Do you have a bunch of jerks that are, telling their, misstating things on their timekeeping cards because management just doesn't care and they're not going to get fired if, you do make a disclosure? Or do you have a culture that says, gosh darn it, we will not, allow that type of behavior? And there's different ways, you can sort of do that, but it needs to be tailored towards the organization.
And Jesse, from a business perspective, how do you accomplish those last three goals? I mean, companies under increasing pressure to keep down their costs, and you do have a business to run. So how do you, as a business person, how do you sort of balance these interests?
Yeah, I mean, it's tough, and Melanie kind of suggested the things that we do. I mean, obviously, we're a mid-sized company. We're not, multi-billion-dollar company with lots of resources. But yes, we have a written code. We absolutely, when people are hired, they get the written code handed to them. They do have to sign it. We have annual training that's actually, we do it online. Oh, and the written code is also posted online for our employees. We do annual training where they have to certify annually to the code, which will include any updates because we review all of our code and policies related to our ethics program annually. So, and we have a third-party hotline. Just, at one time the hotline used to ring in my office. Probably not a really good way to have it work. When Melanie calls and I say, "Hey, Melanie, what are you complaining about?" No. So we have a third-party hotline that's managed, and there's a variety of mechanisms. They can either call or email, or and it's anonymous. So those are all ways we work to comply, and then we do have training. I mean, I speak in the PM forums. I'll have a section on ethics, and when there's an opportunity to have the CEO talk in a broader forum, we make sure that the CEO brings up some ethical issues and compliance issues. So, to the best you can within the size of the organization, you try to use these. This is sort of the bare minimum. But it's constant reinforcement as often as you can. So,
well, do you put a requirement on your employees that if they do identify an issue with time charging or substitution of goods or something, that they have an affirmative obligation to raise their hand?
Absolutely, that's part of our program that they must report. So if there's an issue that even if they're not 100% sure, as long as it's a good faith belief, they should report. They must report.
Do you have them sign a certification that they're not aware of anything periodically?
That's our annual certification. That's part of our annual certification, that they're not aware of any ethical issues, and that they don't have a personal conflict of interest, things like that. So there's actually an affirmative statement that they make every year that they don't know of anything.
I think those records come in handy every now and then.
Oh, they do, yes. Because then when there's a layoff because of a lost contract, and they all come back and say, well, all this bad stuff was happening, and you pull out, well, wait a minute, here you just said for the last 5 years that there's no bad stuff happening. So yeah, it does come in handy.
I want to touch a little bit on the code, compliance program, and internal controls. I wonder if you could just kind of just generally describe what the requirement is.
Okay, sure. So there's a requirement for everybody that's not a small business concern that is doing non-commercial item contracting. So those are the two exceptions to this, right? If you are selling commercial items or you are a small business, you're not required to have this program, although some of them are very good ideas. If you don't fall in those exceptions, you're required to have a compliance program that, we can sort of run through some of these, but you're generally required to have, to think through the way that you are communicating your compliance program to your personnel. So the communication, for example, of we send out email updates on weekly scenarios of how people can think through what would be the most ethical thing to do in a given situation. That doesn't work for somebody that's driving a truck, or somebody that's out in the field, or somebody that's in a hazardous mitigation program. So, in those situations, you may have to use team leaders, and team meetings. Like, you have to sort of think through and tailor your communication plan on ethics. The other thing you want to do is establish a standard to facilitate the timely discovery of problems. This, again, it kind of goes back to what we were talking about, is the government doesn't want you just to react to whistleblower issues. They want you to go out and do internal reviews. They want you to do things that will promote sort of figuring out, are we a healthy organization? Is there fraud, waste, and abuse going on in our organization? And they sort of put that burden on the contractor to do proactively. The other thing that you're required to do is ensure that you have corrective action measures that are appropriately tailored to any issue that arises, and that's where the investigations, really come in handy. You can't, sometimes there's a temptation to say, oh, we have a timekeeping issue, we'll just put a policy in place. Well, what was the real issue with the timekeeping? What was the real timekeeping issue? Was it somebody that didn't understand the policy, or somebody that didn't understand that they could be disciplined for the policy? And the corrective action measure really has to be tailored for the specific issue, which takes us to discipline. You got to be willing to discipline people that are unethical. That should be written into your code. We will fire you if you do not act ethically. And so those are the types of things that are sort of the baseline requirements under a compliance program.
So Jesse, like from a practical perspective, I mean, because your company does a lot of high-end work. They have a lot of ticketed billets, which aren't easy to fill. So how do you enforce the rules? Do you make it a zero tolerance policy? Do people get a warning? I mean, does it depend on what they did? I mean, sort of how do you handle that from a company perspective?
So my policy is fire everybody early and often. No. But I mean, it is almost a zero tolerance. Again, it depends on what the issue is, right?
Right.
At the end of the day. But we sort of, just consistency purposes, we don't want to get into, well, you fired this person, you didn't fire that person, and then, again, you get all these potential risks created. But we pretty much have a zero tolerance policy. Let's take time charging, for example. That's one that, I mean, it's 5 hours they mischarge, but they're like, yeah, I knew, but whatever, you're out, you're gone. There's no second chances. There was a time and a place where we'd have government customers say, yeah, okay, so and so, maybe mischarge, you guys paid us back for it, but we really like the person, the government customer, coming to us saying this, and there was, years ago where we're like, okay, fine, we'll keep them for a while, but generally anymore, no, it doesn't matter. We just don't have time because, most of the time they know. Yeah, they take extra long lunches and charge it, or, smoke breaks and charge it, and it's just, we don't have room for it. So, and it is tough because, security clearances, high-level security clearances, they're really hard to find. And so the business folks want to find 50 ways to keep the person, but we can't. So zero tolerance.
Jeff, when you you've done internal reviews, you've done investigations. When you're looking at people's policies and procedures, what do you see that's missing? I mean, things are missing. Does everybody you work with have a great program, or are there some are better than others, and sort of what makes some better than others?
Yeah, I mean, I think it's some of the things that have already been touched on here, but I think companies that are maybe new to this world are stepping into the arena where they have a covered contract. Obviously, most companies now, commercial or government, have some sort of a code of conduct and compliance and ethics, but the commercial versions of those, obviously, in a lot of cases, don't have the depth or the teeth that you need when you're doing business with the federal government and have a contract that's covered. Beyond that, I think there are a lot of the companies that are getting in the mid to large size that do this pretty well. But if I do see things... Soterra being one of the top ones on the list, yeah.
Excellent compliance program.
No, they actually do have a really good compliance program.
Some of the things, though, that were referred to before, you have this program, you have a bunch of stuff down on paper, you have a hotline, you have the ability to report, but there's a lack of follow-through on things that occur. There's a lack of disciplining employees when something goes wrong. And this gets hard to gauge what's appropriate, but the kind of proactive nature of actually going out there and checking on things, testing things, be that General Counsel's office getting involved in that, your internal audit function, or some other compliance function within the company that's actually kind of testing the program on a regular basis, right? Some of that is sometimes missing.
Should you test it annually, or is it biannually? I mean, how, every 2 years after there's a problem? I mean, sort of what's the best practice to test it?
I think best practice is to have a regular plan in place where you would identify potential areas that you would want to test and have a schedule for doing so. Each area maybe is not tested annually, but there's some regular cycle and some plan.
But of course, that does get complicated based on the size of the company. So that's the issue.
Yeah.
That smaller companies will have they can't have an annual or quarterly audit going on.
Yeah.
Can't afford it. But you try to find other ways to encourage compliance and evaluate. If you get 50 time charging issues, well, clearly there's a time charging issue, and you then actually, not that we've had 50, but we've had specific additional training to try to address that issue for specific groups and things like that. Then you take some targeted training, but that's a tough thing, the whole on proactive auditing.
Yeah.
I think what we see is a lot of people, they'll spend the initial money, they'll pay a fixed price and get their program in place, and it just sits on a shelf.
Sure.
Yep.
Or you'll have people that are entrepreneurs, and you talk to them about the risk, and they're like, I'm an entrepreneur, I eat risk. Good luck with the government space.
You're going to eat this liability, too. Yeah. I will just one quick point, though, for the small guys. A plan to review the way your company is operating doesn't need to be done by necessarily even a third party. If you were to identify a team in your organization that said, we're just going to spot check, but we're going to spot check on this calendar schedule, we're going to, or maybe not, maybe we have an internal schedule, but we don't alert anyone, we just, we do random spot checks of timekeeping to see how, are you telling the truth? And everybody knows we're going to do that random spot check. I mean, there's ways to do it that I do think could help, on the budget side, but accomplish the same sorts of we're flossing our teeth here on the compliance issues.
Yeah, I mean, it's written.
Yeah.
This is written for big companies, but you
Completely.
have to tailor it significantly based on the size of the company.
Designed for the specific circumstances of a company, the areas of risk that they see being most prevalent, and a number of other factors, right?
Right, that's right.
Yeah, and one of the areas where we see, a lot of issues, I don't know that you see a lot of 18 U.S.C. violations, but we do see a lot of potential Civil False Claims Act violations and potential significant overpayment. So I want to focus a little bit just on the False Claims Act And Diz, I wonder if you could just briefly just summarize sort of the False Claims Act and when it applies and, sort of how it arises in the context of mandatory disclosures.
Sure, thanks. So the Civil False Claims Act actually has been around on the books for a long time. It actually arose out of the Civil War. And so fraud has been on the mind of the federal government, and it's one of the few bipartisan issues, especially this day and age. So it's always something to keep in mind because it is a very common tool used by the government to, enforce compliance. And the Civil False Claims Act, unlike its brethren, which is the Criminal False Claims Act, the bar, as Melanie mentioned earlier, the bar for a civil false claim is just a preponderance of evidence. It's not a criminal statute, it's a civil statute, which means that if you violate this statute, you're subject to a monetary penalty. There's no jail time associated with violations of the Civil False Claims statute. But that means there's a lower bar. It's more likely than not that there was a violation. And the violation, the reading of it is a little misleading if you just read the text, which is a civil false claims applies if there's a knowing presentment or conspired to present a false or fraudulent claim for payment or approval to the U.S. government. And we'll break down some of those terms because they are much broader than one would think by just reading, the statute itself. The definition of knowing, the definition of claim, and even the definition of who falls into the bucket of the U.S. government is broader than a lot of folks might otherwise think.
Well, I think the other issue, too, is that, there's a lot of court decisions on this. I mean, they come out not daily, weekly. I mean, you see cases all the time on the Civil False Claims Act. But, the courts have one view of what it means. When you're dealing with an IG or DOJ, the definition is even broader of what's a claim, what the evidence is. Like if you think it's, reckless disregard and you kind of think of that as gross negligence at a trial, I guarantee you if you're talking to an AUSA or an IG or somebody at DOJ Civil, it's just going to be negligent.
It's going to be unallowable cost. Unallowable cost, this is fraud, right? They love to throw that word around.
And Jeff, the situations that you've been in, I mean, sort of what scenarios are you seeing that frequently give rise to potential False Claims Act liability? I mean, I imagine time charging is one, but...
Time charging is one. I mean, if you look at the situations listed out there on the chart, I guess I'd say situation number one, just presenting a false claim or an invoice fraudulent claim knowingly. And Diz alluded to this, as everyone else, knowingly has an interesting definition, right? Intent is not really a requirement. But these days you see other things popping up too, substitution of parts, counterfeit parts, things like that. Selling items that are not Trade Agreements Act compliant, and any number of other issues. But I think you hit it with labor charging, pricing, defective pricing issues, and substitution are the main ones that I've been involved in.
Yeah, I think like charging really has two components. I mean, it has the one component where you charge for time that wasn't worked. You were at home, you were someplace else, but also we're seeing more where the government is questioning whether the person that you put in a specific labor category actually has the qualifications for that LCAT, and they're starting to look at those pretty closely.
On labor contracts, that's definitely a big focus for them because it's more tangible, I guess. Looking at pricing on labor and whether, what type of work somebody's doing, all that stuff is a little nebulous and smoky, kind of hard to figure out. But did this person meet these requirements is simple math, right?
Yeah, it's binary.
Yeah.
Makes it easier for them. So, Melanie, I mean, how do I, what's a claim? How do I know if I submit a claim? I mean, an invoice would obviously be one. How do I know if I submit a claim if I'm hanging out?
If you are in the stream of federal funding, and I mean that broadly. So you get a contract grant, a subcontract, a subaward. You are sort of broadly in that stream, and you know you're in the stream. when you pass on your costs to your prime, you've submitted a claim. Claim is very broad. The government, so in federal government contracting, the government does not have a relationship with a subcontractor. There's no privity of contract. Subcontractors cannot file claims against the federal government. They have to work through their prime contractor because of what's called the doctrine of sovereign immunity. The federal government takes an interesting position, though, when it comes to claims against subs, under the FCA. Even though the government may not have a contractual relationship with you directly, it can still go after you for fraud. And in fact, I would say, in my experience, often it's the subcontractors that are the target, and because they don't, they're not working day in and day out with the government contractor to create the record of knowledge on the government's part. We'll talk a little bit about government knowledge defense. But so if you're a sub, and you're getting federal funds from the ultimate source of the federal government, you have submitted claims when you submitted claims up to your prime.
Now I want to talk a little bit, Diz alluded to this briefly, but I want to talk about sort of what knowingly means, because you have to knowingly present this false claim. What does knowing, Diz? How's that standard apply?
Yeah, that standard is much more than what people would think. It's not, certainly it includes, the actual knowledge that that this is wrong and you're submitting it anyways. You don't have to have the intent of I want to milk the government for every dollar. It's just the actual knowledge that it's wrong can satisfy the knowing prong. But more importantly than that, and this is where contractors typically get into trouble, is the two other elements that fall within knowing. First one is deliberate ignorance of the truth or falsity. And so what that means is that you can't just turn a blind eye to misconduct. That you're aware of people, mischarging or fudging their times or passing through costs that aren't allowable or doing things that aren't appropriate, and you're just not examining it and you're just letting it go. That would be something like deliberate ignorance. That can satisfy the knowing prong. And then the last one is probably the most broad and the one that we deal with the most regularly, which is that you're acting in reckless disregard of the truth or falsity of the information. And that, what is reckless disregard? Well, it's something greater than negligence, because there is, as Paul mentioned, there's cases constantly on False Claims Act, and it's pretty clear that negligence, administrative errors are not Civil False Claims Act violations. But there does become a point where negligence turns into something greater. Most, companies, in fact, the government has taken the position, or courts have taken the position, that if you do business with the federal government, you must be a relatively sophisticated organization to get into business with the government. And in doing so, you are required and you have the obligation to have at least some minimum systems and controls to ensure that what you're billing the government is correct. And so to simply have no controls or no systems, there are cases that have found that type of approach to government contracting is reckless disregard. It is a regulated field, and therefore you should have at least some modicum of controls in place to ensure that you're not mischarging the government. So that can be tantamount to reckless disregard. Systemic problems, failure to train employees. Those are all things that can be, certainly that IGs that we deal with frequently, they'll assert reckless disregard. Now, they may not always win, but the assertion is enough often to create a lot of problems. So you want to make sure that your people know what they're doing, your systems are adequate for the work that's at hand and the billing that's required, because that reckless disregard standard can be quite problematic for contractors.
Yeah, I've seen, there's some cases out there where if a company is just poorly managed, just mismanagement, or putting their heads in the sand, that there can be liability. So, I mean, this is one of those areas that does require our company to be, as proactive as they can be within the constraints of their size and revenue and things like that. About a year ago, there was a decision regarding implied certification that is certainly of interest in this area. And Melanie, I wonder if you could just take a moment and talk about the implied certification theory in the context of a civil false claim.
I could take much larger than a moment to talk to you about the implied certification theory. This theory is, it takes everything we've said and kind of like puts it on some sort of illegal drug that speeds up, the situation. Okay, what is the implied certification theory? So when you submit invoices to the United States government, or you draw down on money that they've given to you through another type of award, usually you submit something that says, we certify that what we're providing you is true and accurate, and that is an express certification. You've expressly certified to your compliance under the contract that your invoices are correct. Implied certification is a theory where also when you submit that invoice, you are making certain representations to the government about either your regulatory compliance, your contractual compliance, or some other legal compliance as you're submitting that good or service. So what do I mean by that? For example, if you are a contractor that provides personnel for a certain type of contract, and say, you're going to hire Paul DeBull, Jesse Waters to do something, and they're going to build a table.
Smart.
They're going to build a really great table. As part of the table, when they send you an invoice, they say, we have built this table and we've built it, in compliance with the specifications of 5 feet by 5 feet. But also part of the contract, you may have said, I want people that have 20 years of experience in building the table. I want people that have a certain accreditation for building tables from this third party. And what the government would say is that when you submit the invoice, you are also impliedly certifying that Jesse and Paul have met those accreditation standards. Now, the reason this is hotly contested in the court, and I mean like hotly contested, I mean, it's like the courts are all over the place on this, is because how do you determine with a 200-plus page contract which regulations, which legal requirements are so important to the government that the government would decide not to pay you in the event that they knew that you weren't compliant with the regulations? And that's the area of implied certification that's really difficult. And I think in terms of mandatory disclosure rule, it becomes a very nuanced judgment call where you have to say, okay, we have been submitting invoices for a period of time in which we were non-compliant with a certain regulation. Does that trigger potential FCA liability such that the government wants to know about the fact that we were non-compliant with this regulation while we were submitting invoices? So that's the implied certification theory in not just a moment, but a few moments.
I want to go up to next slide, talk a little bit about the penalties that can be imposed under the Civil False Claims Act.
Yeah, and I hope that, when I explain that it's civil and not criminal, that people aren't, oh, well, that's no big deal. Well, the penalties can be severe and significant. So the first, and probably still the bigger penalty, is that it can be treble, which is a legal word for 3 times the amount wrongfully charged to the government. Now, if you have an overcharge, 3 times that, it depends on the size of the overcharge. But when you get into some of the things like the implied certification that Melanie just talked about, now you're talking, it's not as quantifiable what the harm to the government was. And in many cases, the government has taken the position that if you misrepresent something, the harm to the government is not, a difference in price A and price B. The harm to the government is actually the entire contract, the entire value of the contract, because the contract was predicated on this material fact that is now wrong. And so that's where things get really dicey, obviously, is that if the government's asserting this $100 million contract, even though you may have performed it perfectly, because we found material misrepresentations, you owe us that $100 million, but times 3. So you owe us actually $300 million. So that is a huge stick. Another notable stick, and it's becoming increasingly notable, is there are fines that can be imposed based upon the number of fraudulent claims submitted, which are essentially invoices or representations or drawdown of funds, depending on the type of vehicle. Originally, those were set at $5,500 to $11,000 per, but just recently, they finally got around to affixing inflation to those numbers, and those numbers have bumped up to ranging from a little over 10 or almost 11,000, 10,781 to as high as 21,563 per violation. Now, think about your business. If you're a high volume where you're generating invoices, multiple a day, there's a lot of organizations out there that do multiple things for the government a day that generate lots and lots, thousands and thousands of invoices. Those numbers can also add up very, very quickly if they're wrong. So while it's civil, the penalties and damages can be crippling.
So, Melanie, should companies just give up hope, or are there actually some defenses to civil false claims act claims? Oh.
Yeah, now that we have thoroughly traumatized everybody, I want everybody to just take a moment, take a deep breath, maybe get yourself a glass of wine, and we will unpack sort of what you're going to do in order to keep yourself safe from this act. There's a couple defenses that are articulated that are legal defenses. I want to just give one nod to sort of the positive of what we've been talking about, and the negative, which is internal controls. So we've been discussing, you have to have this, if you don't have this, if you don't have that, you're going to be in trouble, you need to make a disclosure. But internal controls are also your defense. The internal controls that you set out, it's the company's proactive measure to, one, not have, to mitigate against an overcharge or a false claim, but it's also the company's statement that this is everything we can do to ensure we're doing the best job we can. And reasonable really is the standard for internal controls. So if you have the appropriate internal controls in place, if you tell your people you've got to do, you've got to charge time correctly, you've got to charge, we're going to fire you if you don't, if you do all these things, you will not meet the knowledge standard ultimately, and I think you have a very good case in dealing with the IGs. From a legal perspective, there's something called the government knowledge defense as well. So if the United States government knows, for example, that you are providing Paul's work on the table, but Paul has not been accredited, but they said, you know what, I don't care, we really want Paul anyway. In court, that can be a very persuasive technique to say we did not have knowledge that we were violating the Civil False Claims Act. Now, court, this is back to Paul's point about it depends on the party you're dealing with. Auditors often, they're auditors. They don't care. You don't meet the standard. They're going to write you up. They're going to say it's fraud. They're going to make their statement. But you can sort of create a record, a written record with your government customer that says, these are the exceptions that we are taking to the contract, and when you need to seek modification for those exceptions, you can. That's called the government knowledge defense. The other thing, defense is a reasonable interpretation defense. Contracts are confusing at times. You can have two different interpretations of the law, as we've seen in the circuit splits that have happened over the Escobar FCA case. The most important thing, again, to mitigating against any intent to violate the law is to document your reasoning for interpreting your contract a certain way. And then finally, there's a reliance on expert counsel defense, where you can say, look, we got Venable to opine on this, they told us it was fine, and that is why we relied on it. Here's the one thing I want to say about the expert counsel defense, a gigantic cautionary note. There are cases, and there are certainly plaintiffs' counsel are starting to argue that when you assert the expert counsel defense, you are waiving your attorney-client privilege as to all communications with your attorney on that contract and on that matter. And so, expert counsel defense, sometimes you have a slam dunk and it's worth doing, but be aware that if your counsel has given you advice about certain risks, and as a company, you've made the decision that, we're going to take some of the advice and not all, you are going to waive your attorney-client privilege on that contract, and maybe on that contract in regards to other issues. So it's very, very important that you understand that before you assert that defense.
Yeah, and I think that the one thing with government knowledge you need to be careful of, or government direction, is that, when you make that argument to an AUSA or to Maine Justice, the civil division over there, I mean, one of the things you're probably going to hear back is the person that told you to do something didn't have the authority to do it, and that nobody can ratify fraud. I had a case where we had a contracting officer's technical representative. He wanted the contract performed in a certain way, so he would advise the client that perhaps they should bill for additional labor hours that weren't being provided on the contract, and then use those funds to go buy a car that he thought was needed for the contract. And, the client wasn't very sophisticated. They thought they had to comply with whatever the COTR wanted, and they went and they did these things, funded other slots. And, when you lay the case out in front of Maine Justice, their initial position was that that person didn't have the authority to make those orders, and you can't ratify fraud. So,
right.
There's always that dynamic. You always have what the rules are, how a court's going to apply them, but it's a different calculus when you're actually trying to negotiate this. And I think the DOJ understands that, and I think that's why they're willing to take more aggressive positions, because they know that a company, when looking at paying a potential fine, may be more willing to pay the fine than incur the legal fees and have this thing drag out and distract the company for a number of years. We touched briefly on some of the problem areas that arise, and I just wanted to get Jesse's comments on some of these problems areas, as well as Jeff's comments, like, what you see, how does it arise, sloppy time charging, is it people not showing up for work, is it people showing up half-time, is it, what do you see when, in these issues?
So I think, like you said, we kind of touched on this earlier. I think the most common thing that any company, when you have thousands of employees, it's time charging, and it's sloppy time charging. And, sometimes it's, they knew. Sometimes it's like, I didn't know that I couldn't take lunch for 3 hours and not charge. So I think that's probably, the most common area. And then, yes, I think we see more of the labor category issue that sometimes that is being raised, inappropriate labor categories. It's the wrong people in those labor categories, and they don't qualify. But by far, at least we don't. We're pretty clean from other stuff, I think, but it's time charging.
Yeah, I think I'd add to that, that particularly when it comes to mandatory disclosures, and maybe not making its way to False Claims Act, because you can mitigate some of that risk by making a disclosure, right? The issues we've discussed, and just as Jesse said, there could be some others in the GSA world, effective pricing and PRC. I'd add on to what we've talked about as well. A lot of cases, though, these things come up post-acquisition, when somebody buys another company. There was some diligence done, and maybe there's even some government contracts compliance kind of diligence done, but it maybe didn't get to the level where it was quite deep enough to really detect some of these issues. Usually bigger acquiring company has more sophisticated systems, more at risk, so they're not going to let some issue fester and not disclose it, right? And so kind of post-acquisition, they start operating and they say, uh-oh, we've got this problem, or, whatever it might be, we need to go make a disclosure, so.
We see that a lot. The post-acquisition, we see, or during the negotiation process, we see a lot of false notification on, status, like small business, women-owned, veteran-owned, that need to be disclosed. And that, there are times when it goes back to the entire history of the company because they've never actually qualified. They didn't realize that, like, so many levels or whatever don't act,
is left at that point.
Yeah, and that is the certifications that involve the status certifications, the small business certifications, those are the ones that trigger the entire value of the contract. Some of the other certifications, express certifications, you don't actually trigger the entire value, but the small business stuff is not anything to mess around with.
Yeah, and on Jeff's point on M&A activity, we certainly see disclosures after the deal is closed, but even during the due diligence process, if something comes up, we've seen any number of scenarios that as one of the prerequisites to close in the deal, that the mandatory disclosures need to be made before you even get to where you're signing the documents. And I think that makes sense in a lot of instances because you want the company that caused the problem to own it. And if you start disclosing after the purchase was done, you have to explain a little bit that it wasn't us, it came in this way, whereas let the company that did this in, let them do it, and then try to bring it in. But I've seen at least 3 or 4 recent deals where they had to do a mandatory disclosure before it was even going to close, which was
in a separate escrow sometimes,
yeah.
Or potential issues. Fraud's always a carve out in any M&A usually, but sometimes separate escrows to deal with questionable issues.
By far the most nightmarish situation I've ever seen is the situation we have a cost-based contract where a contractor hasn't done total time accounting, so they haven't been recording. This is a situation where you're required to record all of your time for a day, and then you normalize your rate, to a 40-hour work week. So if I, ordinarily charge $10 an hour for my 40 hours, but then I work 50 hours, I have to, pretend like I only work 40 hours in order to get a particular rate. It's very difficult medicine to unwind when you haven't understood the difference between a cost contract and a time and materials contract where you have a specific rate that is just tagged with the contract, and that's what you charge. So understanding what your contract requires is very important from the get-go.
Yeah, and understanding what contract you need to charge to if you're doing multiple projects. That's
another issue that we see sometimes is, you've got cost type T&M work, and you've got budgets, and you have fixed price contracts, right? And magically, some of those hours that should have been recorded on the fixed price contract end up on the T&M or cost type contracts.
Mm-hmm.
Yeah.
Moving money around.
I had one client that doesn't exist, but they would come in every day and they'd have a list of they'd have a list of contracts with money, and they'd go, okay, you charge to this one, you charge to this one, you charge to this one, you take your 8 hours today, and they would call it peanut buttering. They go, you peanut butter against these 4 these 4 charge codes. So that gets to the point that Jesse made earlier, that you really do need sort of compliance at the top, and it needs to be a constant message, and you certainly can't engage in those type of practices and then be surprised that somebody doesn't think you have a culture of compliance. So it's I want to talk a little bit. We have about 20 minutes left. And I want to talk leave some time for questions, but also just some of the potential indicators of fraud. We have like cost mischarging examples. So I don't know, Melanie, if you want to talk about sort of what you've seen, or Jeff and Jesse, what you're seeing, just sort of like in a cost area, like what causes the red flag to go up? Like what do you see? What do you hear? I mean, what do you know? Just like, oh, maybe we have a problem.
In my experience, the sort of cost mischarging issues arise more often from whistleblowers, and they could very easily have been mitigated by greater control over who has access to charging on a contract. So you say these are the time charges you're allowed to use, and it's not a free-for-all. You just, you only allow certain people to charge on a contract. And then we have very strict controls and judgment for how we're going to move time from one contract to the other. Those are the mitigation tools that I see, but they're mostly, I mean, in the grant, if you're in a sort of non-contract world, you're in a grant world or any cost world where you have unallowable costs. It's when people who don't do sort of the live and breathe that cost type contract work, they stick their pinky toe in it, and then all of a sudden they've done it completely wrong because they're not used to, maybe they're used to working off of a T&M, GSA type model, and they're just not used to the very strict requirements for cost-based contracts.
I mean, I think that's right on. I think if you think about indicators or red flags, it's lack of policy, lack of control. There are system-based controls, like you just mentioned, which restrict what projects somebody can charge to, right?
Yeah. We do the same.
Having those things in place is good indicators that you might have things pretty well under control. Not having those kinds of things in place are an indicator that you might need to dig a little deeper, think about how you're going to control the way you operate, in other manners.
If you have a cost-based contract, and I usually don't make this like a statement, but if you have a cost-based contract and you're manually doing your time, that's a difficult situation for you to be in. That's a difficult situation. It's really difficult to make sure you're doing the entire process correctly.
And in the next slide, we talk about indicators of fraud, product substitution. I mean, do you guys have any familiarity with dealing with these types of issues? I mean, certainly you see accusations that test documents have been doctored. I mean, is there any way to prevent that? I mean, I think one of the problems with the civil false claims is you can't impose morality on your employees, and some of them are just going to do the wrong thing.
Unfortunately, I mean, that's the reality, and I was not that big. Soterra never had these issues. But yes, I mean, we've had issues at times. Theoretical companies have had issues at times where yes, you can't control the employee. You have all the procedures in place. Name it, moving time or test procedures or contract documents, and employees know better, and they act inappropriately. And there's not much when you find out about it, again, you disclose it and whatever. But there is no additional procedure I can put in place other than shutting down the company to prevent that from happening.
Is there a way to incentivize, Jesse? It seems to me that, obviously I agree with what you're saying, but perhaps like what you don't want to have, for example, is compensation tied to performance necessarily, because there could be the incentive to, say that something performs in a certain way when it doesn't, and you're incentivizing that.
If you're saying incentive tied to the performance of, let's say, a product, that's very unusual to see that. In my experience, clearly there's incentive tied to performance of your contract, and which could also provide negative incentives for people to try to bolster their numbers. But that's across all businesses. You got to tie performance to to your compensation. But rarely, I mean, and I'm not saying it doesn't exist, but rarely have I seen it tied to, let's say, the performance of a product. Like it goes this fast or
Right.
operates this well that, you get some additional bonus.
Okay.
So
I think a lot of it comes back to tone from the top, right? And having
absolutely
a culture, and then beyond that, having the things in place that you need to around training, internal controls, compliance, so that if something goes wrong, you can at least point back and say, look, I did all these things to try to get it right, to try to prevent it. And hopefully you avoid the false claims realm and you're more in the disclosure realm.
Yeah, I mean, even though I hate cliches, tone from the top is like, it is so essential. If your CEO sets the tone and it will flow down in every aspect of compliance, ethics. It absolutely will.
Yeah, and I think, Jeff brings up a good point that, you do want to have procedures and processes in place so that you can say you did all you could. Because if it goes to a suspension debarment official, and let's say you have an employee or a subcontractor like colluding to get money that they're not entitled to, they're going to want to know, what did you do to prevent that? And sometimes just saying, these two were bad actors isn't going to be enough. So you're going to have to explain that, look, this person had training, this person signed this certification, this person verified at the end of the year they weren't aware of any fraud. We relied on those things. Or if you have timekeeping issues, you want to make sure that the person that is mischarging, that you have timekeeping procedures, that they were trained on them, that they certified that they were going to follow the applicable procedures, and then, you've done what you could do. And then you take that to the government and say, look, the person's a bad actor. Like, I don't know what you want me to do. They swore up and down, they understood, they swore up and down, they did the right thing, and guess what? They didn't do the right thing. But I do think most of it in this area, and avoiding false claims and avoiding mandatory disclosures, prevention, I think it's probably everything, right? So I wanted to talk a little bit, go up closing minutes, just talk about some of the practical tips that we had offered companies to minimize the risk of running into a civil false claim, or to minimize the risk that they're going to have to make, a mandatory disclosure, because, nobody wants this unwanted attention on their company, right? You just want to do your job, make your money, and move on. But, so what are some of the practical tips, Melanie, for trying to minimize this risk?
I think I'll just speak more broadly. You got to have a plan for compliance. You got to know what your contract says. Somebody in the company has to know what your contract says. So I guess point A is have somebody know what the contract says, and how you're going go through. We create compliance matrix with our clients. You go through, you say, this is how we're complying, or this is not applicable to us, and you sort of map that out. That's step one. And then I think, everything that these guys have been talking about with creating a tone of accessibility to management that says, we want to hear if you have problems. You as the people with boots on the ground that are doing this project, you not only will be well received for bringing us the problem, but you will also you will be disciplined if you don't. And we really expect that you're going to sort of, if you see something wrong, please come and talk to us, because the last thing you want for them to do is to run off and talk to somebody else and not give you an opportunity to correct or to educate them on why it's not a problem.
So with the emphasis on implied certification, are companies doing anything differently when they're making certifications to the government, or are companies looking at contracts to see what certifications are included as part of the invoice, prompting the government to pay? I mean, is there any additional analysis, or is it just...
Well, you try to, again, it's all about resources at the end of the day,
right,
too. But we all, clearly, when we're submitting proposals, we try to be, we have compliance matrices when we're submitting proposals to see all the areas that we need to comply with, and check off that we're complying with it and we're answering it properly, and that the certifications are accurate. That's the first line of defense. we have a rigorous review of our invoicing. Both the PMs are supposed to review it, and then we have billers that review the invoices, and we have a process internally to ensure that they're accurate. Beyond that, again, it sort of depends on the size of your company and if you can add additional procedures. But I think that's that'll should handle most of the issues.
Jeff, what have you seen that companies are doing or not doing in the cases that you've been involved in?
Yeah, and I was thinking about this prior to the presentation, and you mentioned something that I had on my list, and then you were alluding to something else I had on my list. I think in some of the key processes, involvement from multiple disciplines is really important. So bid proposal process, invoicing, contract compliance. It's not just in a vacuum with one person dealing with it. You get legal involved, you get finance involved, you get pricing involved, and you get sales involved. They all have different motivators. Some of those motivators are the great ones. Some of them are different for good reasons, right? So having all those perspectives is important. You mentioned, although I don't know if you use the exact word, but contract briefing, developing a compliance matrix.
Yeah.
What do we have to comply with from a contract perspective, a regulatory perspective, a contract performance perspective? What are all the things we need to be aware of so that we can make sure we have the things in place to actually, take the proactive steps that we need to take? Training on a regular basis is important, and then some level of, we talked about this before, depending on the size of your company or resources, some level of kind of proactive review of, are we getting all this right? I think is a best practice.
Sure.
Now, some of the other practical tips that we offer clients appear on this slide. I was curious, Jeff, your company, do you guys do exit interviews of former employees to see if they know any problems, or do they just sign a certification when they leave that they're unaware of problems? How do you guys handle that?
We do have exit interviews. You can always improve on those. I think that they're not very effective, unfortunately, I think, for the most part. Mm-hmm. Employees generally don't want to say anything when they're leaving. They don't want to burn bridges unless it's an employee leaving because we lost a contract, then everything was fraud. But we do have them, and just we don't find them an effective tool for any purpose, not even for recruiting and retention purposes. It's really not an effective tool. But that being said, we do that. So, I think we don't, knock on wood, we don't have a lot of issues overall in the company, but there's definitely, people know that we do have a culture that you can they come talk to me about their dogs. It's pretty safe. Feel free to walk in my office and talk about their dog. They'll tell you anything. And, so I try not to, shut the door, but, no, so, it's really, setting that tone that they know that everybody's, accessible, and they need to bring it up through any number of mechanisms that we have available.
Okay, so I was just going to get a few minutes left. I want to leave a couple minutes for questions. So I wanted to give each of the panelists an opportunity, if I was going to say, identify 1, 2, or 3 of the top key takeaways, lessons learned in the context of the mandatory disclosure or civil false claims act. What would be sort of the 3 takeaways or top 3 points you'd offer, Justin?
Top 3 points. Well, it's really, again, it's not that hard to put a program in place. It really isn't. It's the bare minimum, and it's to just make sure that you educate your employees on the program. Again, like we do, the code of conduct. Not that hard. You can always get Venable to help, or anybody outside to help you get at least that basic code, and then just training them, educating them on that, and make sure you have that culture that they can come and report. Because believe me, I want people to call the hotline. I'd much rather have people call the hotline than find out through a key TAM suit or the government calling me. It's going to save the company a lot of time, money, and trouble. So,
Well, maybe you, Jeff.
we were talking a little bit before the presentation began about taking the care to get things right, even if it costs you a little time or money. In the long run, getting it right up front is a much easier thing to do than trying to fix it after it's gone wrong, no matter what type of contract it is, even if it seems simple. I think for me, second, we talked about some of these things. If you uncover what you think might be an issue, don't forget about it. Move quickly. Make a decision about it. If you need to make a disclosure, start the process of doing that. And then if you do make a disclosure, taking the time to be thorough, to get it right, to present logical arguments. They don't always have to be the arguments that you think the government's going to agree with 100%, but present them logically in a way that's understandable so that it is easier for the government to review what you've provided and hopefully agree with what you provided without going into their own full-blown audit, because that's a lot more pain that you might have to deal with.
What are you, Melanie?
I think you got to have a plan, generally speaking, and I'd say that for everything. Plan for internally reviewing, plan for who's responsible for even making it the decisions about a disclosure. Do you have to get board approval? Do you have to get the GC to decide? Plan for how and who you're going to get to investigate that. I think you got to tailor the corrective action measures to the real issue at hand. Government loves that. I've had so many conversations with IGs that have gone much better than I thought they would, because no matter what the problem was, if you really identify it and you say, here is how specifically we are fixing this problem, this very specific problem, and here's why this works, I think you make their job as an IG much, much easier, and SDOs love it too. And then, as far as culture of compliance, I think, I know we live in a digital age where everybody likes to talk on the phone and over internet, but FaceTime is important if you're the person in charge of compliance. Like Jesse was describing, people can come in and talk to him about his dogs. I mean, if you have employees all over the world, but you're in charge of compliance, I really recommend that you get on the road and meet the people face to face and make sure that they know I'm the person you come to talk with about problems, and I care about you and I care about the company. So I think FaceTime is important.
Diz, what do you think?
First of all, I agree with everything the other panelists went through. Those are absolutely important things. And the only thing I would add is document would be my three things. Document your interpretation of unusual contract terms. Document your discussions with the government to solidify that government knowledge. If there's side deals with the government in terms of, this person's fine despite not meeting the labor quals. There's document that stuff, because it is gonna override a fraud allegation. Document that your people are receiving training. Because those types of that having those controls, those documented controls that are actually done, are going to help negate fraud. And then if you can negate fraud, then you can negate mandatory disclosure. So too often, companies try to do the right thing, but they don't document it, and so then you're left with not a lot to present to convince an IG otherwise. So document that stuff and put it in the contract file so it's readily accessible and can be presented to an IG if there's ever any question.
Yeah, I think the one takeaway that I have on the mandatory disclosure letter, I agree with Diz that you should not use the form on the IG's website. You should print out that form and use it as the basis for your letter, because they're going to want to see things organized the way the form is laid out. And then I think as you're putting together your mandatory disclosure, you want to be as factual as you can and not characterize what's occurred. It's just, here are the facts, we're going to give you the money back, and you just stop there. Because I think the more you can put stuff into a contract administration issue that you can get resolved at the contracting officer level, the better off you're going to be. Now, it doesn't always work, but I think I've had the most success in just presenting just sort of a discrete factual recitation. This happened, here's what we're going to do about it. Let me know if you have any issues, and then, hopefully you never hear from. Okay, great. Next month we'll be doing an update on the Escobar decision, which we briefly touched on today. I hope that you'll found this informative and that you'll join us next month. And again, I wanted to thank the panelists for coming today, and I wanted to thank those of you who joined us on the webinar, and we look forward to hopefully having you participate next month. Thank you.
Thanks so much, everyone.
And again, ladies and gentlemen, this will conclude today's conference. Thank you for your participation. You may now disconnect.